for a lot of people, they say, well, the judgment did not say that there were no, outrightly say there were no issues with the election. It just said it could not prove certain things that the
petitioners could not prove.
The petitioner could not prove.
Yeah.
So then the question many had to ask, I wish my lawyer guest was here already. Perhaps he would. But as an analyst yourself and a Nigerian, when you then look at that, do you then say, oh, some people I spoke with said that means the judges knew that there were issues. So because we can't prove that there were issues, you would now say, let us, based on what is on the Constitution and the provisions, issues or not, this document doesn't support that. So there's nothing we can do. We have to put it this way. Do you think that the judges had done justice if we are looking at the angle you came from acting outside the law in certain instances, to point out certain things that were obvious and needed to be questioned?
In going outside of the law, sometimes you are now giving admonitions. That's why I use the word admonition.
So it wouldn't be the
caution.
Judgment based on outside the law, but you could
of course you could give certain admonitions and say, look, based on what all the petitioners had said, INEC itself came out and said, look, we organize the election this way. We'll use electronic method of transmitting results and all of that, for which the judges too were aware. You could go outside of the law, outside of the hard evidence that should have been before you, to say, look, INEC, we are disappointed in you. Look at what you've made these petitioners to go through. Look at what you've made Nigerians to go through. These are general admonitions to an institution. But when it comes
despite the judgment,
yeah, you could admonish, you could caution, you could give words of advice. It's within the powers of a judge to be able to do that. But when you want to prove something, the court has to rely on the evidence before it. Remember, precedences will be set. You know, the moment a judgment is given, you're already setting a precedence until it is upturned. So you need to be able to put something together that will ensure that it lasts the test of time if you are going to give a judgment in that regard. So they needed evidence, before it. I'm sure you are aware that the petitioners had complained that INEC gave them tough time to be able to access.
And some did not even get all the materials
some of what they needed. So I felt, and these were part of the briefs that the lawyers of the various petitioners gave before the tribunal to say, look, we had difficulties in even getting some of these things from INEC. I felt that the tribunal, judges should have taken particular note of why INEC would refuse. You conducted an election. People who contested in that election say, look, we need these materials. Then INEC became a hesitant. Why would INEC do that?
People would want to know for you whether you would advise for an appeal. If you were a legal advisor to any of these parties,
of course, I have.
What would change at the appeal?
I have weighed in APC against Sariaki Dixon. A just concluded case. The same court of appeal, in her wisdom, said because the court accepted from the beginning to subpoena these persons, that those witnesses becomes the witness of the court. That alone.
But that did not apply in the presidential.
No, that's what I'm saying.
That
is a precedent which contradicts the current ruling. There is a precedent which has been established by the law. I said it from the ab initio that the law is the prophecies of what the court will do, and in fact nothing more pretentious than that. And I want to say that because there is a contradictory position, there is a test to be conducted in the Supreme Court.
Good.
I understand that the financial implication could be heavy, and some of us who are far cannot contribute money. I'm not speaking for Labour Party. I've never been a member of Labour Party. Except in the nearest future. But for today, I'm not a member of Labour Party. But I know that once there are substantial evidence to prove to the Superior Court that the position which was taken by the trial court is in contradiction with the original established principle or fact or law, as a matter of fact, the Supreme Court will have reason to grant.
To grant
that appeal. Okay. So there is a reasonable ground for Labour Party to appeal.
For many people who went to vote and saw certain illegalities happen, and then expected that, well, in the courts, these things would have played out, and then they would see, and then okay, and if it happens that way, they would accept whatever judgment that comes. But they didn't see that happen. Where does this then put us? We know that the judiciary did what it did with the laws that we have and the ability of those who presented their case to to show that, okay, these cases, these allegations are true. But when you look at how it has played out and the perception people now have of judiciary, how do you explain the way going forward to make this better?
I think it's also,
is it adjusting the laws?
Yes,
what do we have?
It's also part of the problem, if I got you clearly, that for me as a lawyer and as a person that I'm also having or feeling now, you recall that during the trial of this particular suit, there was an application that was brought to the court to allow it to be televised.
Yeah.
And the court,
I asked him that question and said no, but then televised the results.
Because this question now, that would have explained it better, because we would have known whether those evidences were actually tendered
adduced or not.
So if we had it live,
yes, none of us were there. So how can we even testify or give accurate fact as to whether or not those material evidences were actually produced to the court? But the truth of the matter is that Nigerians believe that, yes, because of the fact that you refused the application, it is an application of Nigerians. Because you refused that particular application, which would have availed them the opportunity of citing for themselves the errors of the council, coming back now to blame the council of Labour Party or PDP, it's like a white ghost chase.
All right, Mr. Ige, quickly, for you, what do you make going forward now? How do we handle this? For people to say, I saw this happen and I go to court. At least the court, I should see justice in the sense that what I saw happen reflected in court, and not the court giving me a judgment based on the law and what I was able to show them as against what really happened that I saw.
I think we must fundamentally reform INEC then. INEC is crucial to the evidences of the opposition parties, those petitioners, and I felt that INEC should have done more. And the fact that the tribunal even excluded INEC from admonitions is what is shocking to me. Then I think we now need to go forward, amend the constitution further to say, look, INEC must now transmit results electronically. Not that INEC has already had the powers to be able to organize election, determine how it wants to conduct election and all of that. And because of that, you can't hold INEC, to responsibility because it didn't transmit the results electronically. I think we can now make that mandatory for INEC, that look, while we are using BVAS, which is in the Electoral Act, at the same time, we must be able to vote electronically, or we must be able to transmit results electronically.
Right,
that might be a game changer.